He didn't read the room. That was the thing nobody talks about. How a man can stand in the middle of a moment that should break him open and feel absolutely nothing. Vivian Ashford had spent 11 years learning how to read her husband's silences. She knew the difference between the silence that meant he was thinking and the silence that meant he had already decided. The silence in the conference room that Tuesday morning was the second kind. She had driven herself to the building. That should have been the first sign. Randall used to pick her up for everything. Client dinners, award ceremonies, the opening of his second office on Michigan Avenue. But that morning he'd said he had an early call, and she'd said fine, and she'd parked in the visitors' lot like a stranger visiting a place she'd helped build. The firm was called Ashford & Vale. Her name was on the door. Her name was also on 17 patents, 9 licensing agreements, and a foundational software architecture that powered the building management systems in 43 commercial properties across Illinois, Ohio, and Georgia. She had written the original code in the second bedroom of their apartment in Wicker Park, the one they'd converted to an office, because they couldn't afford a real one yet. Randall had brought her coffee and told her she was a genius. That was 12 years ago. She was 41 now. She still brought her own coffee. The conference room had floor-to-ceiling glass on 2 sides. She could see the whole open floor. Her developers, her project managers, people she had hired personally, pretending not to watch what was happening inside. Randall sat at the head of the table. Across from him sat a woman named Tessa Moreland, who was 29 years old, who had joined the firm 8 months ago as a senior consultant, and who was wearing the same perfume Randall had come home, smelling of 4 times in the last 6 weeks. Vivian had not said anything about the perfume. She had written it down in a notes app on her phone, time-stamped, because she had learned, somewhere between year 6 and year 7 of their marriage, to document things quietly. There was a third person in the room. A man Vivienne didn't recognize in a charcoal suit, with a leather portfolio open in front of him. He stood when she walked in. Randall did not. "Vivienne," Randall said. Not Viv, not sweetheart. The full name, flat and procedural. "Sit down." She sat. The man in the charcoal suit introduced himself as a partner from a firm she'd never heard of, and he slid a document across the table before he'd finished saying his own name. She looked at it. She looked at her husband. "You scheduled a meeting," she said, "to serve me divorce papers." "I scheduled a meeting to have a professional conversation. In our building. In my building," Randall said, and that was when Tessa looked down at her hands. And even she seemed to understand that something had shifted in the room, that the ground had moved in a way that couldn't be unmoved. Vivian did not pick up the document. She had learned that too. Never touch what you haven't had reviewed. She folded her hands on the table. "I'll have my attorney contact yours," said. "Vivian, I think we can handle this like adults. We are handling it like adults." She stood. "I'll be in my office." He said her name again, sharper this time, but she was already walking, and her heels on the hardwood floor were steady and even, and not a single person on that open floor met her eyes as she crossed it, which told her they had all known before she did. Her attorney was a woman named Dorothy Bash, who had been practicing family law in Chicago for 31 years, and who had in that time developed a specific expression she used when a client came to her with something that looked like a disaster but was actually an opportunity. She was wearing that expression now. "Walk me through the IP assignments again," Dorothy said. Vivian walked her through it. The original code, written before the firm was incorporated. The patents filed in her name. The licensing agreements she had negotiated herself. Before Randall had brought in a business development team, back when it was just the two of them and a shared Google Drive, and a dream that felt too large for the second bedroom in Wicker Park. When Ashford & Vale was incorporated, Dorothy said, "What did you assign to the company?" "The right to commercialize the architecture, not the architecture itself." Dorothy wrote something down. "And the patents, still in my name. The company holds a license." Dorothy set her pen down. "Vivienne, do you understand what that means?" She did. She had understood it since year 7, when she'd consulted a different attorney, quietly, at a lunch she'd told Randall was a client meeting, and had learned exactly what her ownership position meant, and had gone home and said nothing and filed the information away in the same place she filed the perfume timestamps and the late nights and the way Randall sometimes looked at his phone and angled the screen away from her. She had hoped she would never need any of it. She had prepared as though she always would. "His attorneys are going to tell him he owns half the firm," Dorothy said. "He owns half the firm." "But the firm's primary revenue stream, the 43 properties, the licensing fees, that all flows through your IP, yes, which he cannot touch without your consent." "No." Dorothy picked up her pen again. "His attorneys are going to figure this out." "I know. Probably within the week." "I know that too. Are you ready for what happens when they do?" Vivienne looked out the window. Dorothy's office was on the 34th floor of a building in the Loop, and from up here the city looked clean and ordered, all geometry and intention, nothing like it felt at street level. She had always found that comforting. The idea that from far enough away, chaos had a shape. "I've been ready for 2 years, she said. The call came on a Thursday evening. Not from Randall. He had stopped calling her directly once the attorneys got involved. But from a number she didn't recognize, and she almost didn't pick up, and then something made her. It was Tessa. She had a voice that was younger than Vivienne expected. Softer. Not the voice of someone who had spent 8 months dismantling someone else's marriage without apparent guilt. She said she was sorry. She said she hadn't known about the patents. She said Randall had told her the business was entirely his, that Vivienne was a silent partner in name only, that the divorce would be clean and simple, and that by March they would be free. "Why are you telling me this?" Vivienne asked. A long pause. "Because he told me the same thing about his last assistant," Tessa said. "The one before me, and I just found out she signed an NDA." Vivienne was quiet for a moment. "How many?" she said. "I found 3, Tessa said. "There might be more." Vivienne thanked her. She hung up. She sat in her kitchen, which had a marble island she'd picked herself, and copper, pendant lights she'd waited 4 months to find on a vintage site. And she thought about the man she had believed in so completely that she had spent 4 years writing code in a converted second bedroom while he slept 8 feet away, and she thought about all the ways a person could be standing next to someone and be entirely alone. Then she called Dorothy. Randall's attorneys were good. She'd expected that. He'd always known how to hire people. They sent a 40-page response that laid out a theory of implied assignment, argued that the IP had been developed in the course of the marital partnership, and was therefore subject to equitable division, and included 3 exhibits she recognized as internal documents from the firm's shared drive. Dorothy called it aggressive. Vivienne called it predictable. What Randall's attorneys had not accounted for, what Randall himself had never bothered to learn, because he had always left the legal architecture to her while he ran the client relationships, was that Vivienne had restructured her IP holdings 14 months ago, quietly, through a separate LLC incorporated in Delaware with Dorothy's firm as registered agent. The patents had been assigned to the LLC. The LLC was wholly owned by Vivienne. The LLC was not a marital asset. It had taken her 8 months to arrange. She had done it while attending Randall's client dinners, while planning his firm retreat in Scottsdale, while drafting the talking points for the keynote he'd given at a commercial real estate conference in Nashville, where Tessa had apparently also been present. A fact Vivienne had learned later and filed away without comment. The night Dorothy explained the restructuring to Randall's legal team, Vivienne got a call at 11:45 p.m. She did not pick up. She let it go to voicemail. She did not listen to the voicemail until the next morning, standing at her kitchen counter with her coffee, and she listened to Randall's voice, controlled at first, then not, saying things that would have devastated her in year 3, or year 6, or even year 9. By year 11, she had learned that anger from a person who had wronged you was just their grief wearing a mask. And she had stopped taking it personally. She deleted the voicemail. She drank her coffee. Outside, Chicago was gray and cold and absolutely itself. The deposition was scheduled for a Wednesday in February. Vivienne had been in depositions before. Contract disputes, licensing disagreements, the ordinary friction of running a technology business. And she knew how to sit still for hours and answer only what was asked and show nothing on her face that she didn't intend to show. Randall's lead attorney was a man named Clifton Howe, who had a reputation for being unpleasant in rooms where unpleasantness was a strategy. He started with the chronology of the IP development. He moved to the nature of the marital partnership. He introduced the implied assignment theory 3 different ways and watched her face each time he did it. Miss Ashford, he said, not Mrs. She noticed, a small deliberate choice. Would you characterize your role in the development of the Ashford architecture as occurring within the context of the marital enterprise? No, she said. You developed it while married to Randall Ashford.
I developed it before the firm existed.
I was married to Randall Ashford at the time. Those are two different things. The firm was built on that architecture. The firm was built on a license to that architecture. The license is in writing. I can provide the document. Dorothy had advised her to provide documents, not explanations. Documents were neutral. Documents didn't have feelings. Documents were harder to argue with than a woman who looked angry or hurt or scared, and Clifton Howe was clearly hoping she would become one of those things so he could use it. She didn't. He shifted. Asked about the LLC restructuring. Asked whether the restructuring had been intended to shield assets from equitable division in anticipation of divorce proceedings. I restructured my IP holdings to clarify ownership and reduce liability exposure, she said. My attorney can speak to the business rationale. Were you anticipating divorce proceedings at the time of the restructuring? I was protecting my intellectual property. I've been doing that since 2014. He paused. He looked at her in a way that was meant to suggest she was hiding something. She looked back in a way that was meant to suggest she was simply waiting for the next question. The deposition lasted 4 hours. At the end of it, Clifton Howe gathered his papers with the particular efficiency of a man who had not gotten what he came for and did not want anyone to notice. Vivian signed the certification. She thanked the court reporter. She rode the elevator down with Dorothy, who said nothing until they reached the lobby. You were extraordinary in there, Dorothy said. I was accurate, Vivian said. That's all. The settlement negotiation stretched into April. Randall's attorneys kept finding new angles, new theories, new ways to argue that the architecture was marital property, that the restructuring was a fraudulent transfer, that Vivian had somehow conspired to deprive him of what was rightfully his. Each theory was more strained than the last. Each one Dorothy dispatched with the patience of a woman who had seen all of this before and found none of it interesting. What was interesting? What Vivian found herself thinking about in the evenings, when the city was quiet and the copper pendant lights were on, and she was sitting with a glass of wine and the particular stillness of a house that had once been full of someone else's noise, was the 3 NDAs. She had asked Dorothy to look into it. Not as part of the divorce proceedings. The NDAs were between Randall and former employees, and technically outside the scope of her case. But Dorothy had a colleague in employment law, and the colleague had a quiet way of finding out things that people paid good money to keep buried. What she found was not entirely surprising, and was also, somehow, still a shock. 2 of the women had been employees of the firm. 1 had been a client. All 3 had signed agreements that prohibited them from disclosing the nature of their relationships with Randall in exchange for settlements that ranged from $40,000 to $95,000. 1 of the women had also agreed not to pursue an employment discrimination claim that had nothing to do with the relationship and everything to do with what had happened after it ended. Vivian sat with that for a long time. She thought about the woman who had taken $40,000 and signed her name to silence. She thought about what $40,000 buys. A few months of rent, a car, a breathing room that feels like freedom until the silence starts to cost more than the money. She thought about whether Randall had believed, when he handed over those checks, that he was settling debts or buying peace, and she thought those were probably the same thing to him. She called Dorothy. Can any of them get out of those agreements? She asked. Depends on the jurisdiction, the language, and what they're alleging, Dorothy said. Why? I want to help if I can. A pause. That's outside the scope of our engagement. I know. I'm not asking you to do it. I'm asking if it's possible. It's possible, Dorothy said. It's also complicated. And expensive. I know what expensive means, Vivian said. The settlement came in mid-May. Randall got half the equity in Ashford and Vale, which was his right, as co-founder. He got the Michigan Avenue office building, which they'd bought together in year 7 and which had appreciated considerably. He got the house in Lincoln Park, which Vivian had not fought for, because she had not wanted to win the house. She had wanted to win the thing that mattered. What he did not get, the patents, the LLC, the licensing agreements, The 43 properties whose building management systems ran on her architecture and generated, at last count, roughly $4.8 million annually in licensing fees. He did not get any future revenue from those systems. He did not get the right to use the architecture in any new Ashford and Vale project without entering into a new licensing agreement with her LLC at rates she would set. Clifton Howe had fought that last point hardest. He had called it punitive. He had called it, in one memorable moment during a particularly tense negotiation session, vindictive. Dorothy had looked at him steadily and said, "It's a licensing agreement, Clifton. Your client should be familiar with those. His company has been operating under one for 11 years. Randall signed the settlement on a Tuesday. Vivienne signed it on a Wednesday in Dorothy's office, with coffee she'd brought herself in a thermos from home. She did not feel triumphant. She had expected to, and then she didn't, and she thought maybe that was actually the more honest outcome, that there was no version of this that felt like winning because winning implied the whole thing had been a game, and she had never wanted to play. What she felt was lighter. Not happy, exactly. Just lighter. Like something she had been carrying for years had been officially set down, and she could finally feel her own arms again. She left Ashford and Vale in June. Not because she had to. Her ownership stake, minus what Randall had taken, was still substantial, but because she didn't want to build anything else in a space that had her former name on the door, in a way that no longer meant what it used to. She took 3 members of her original development team, the ones who had been there since the second bedroom in Wicker Park, the ones who remembered when there was no firm and no Michigan Avenue office and no 43 properties, just a woman and her coffee and an architecture that didn't exist yet. She called the new company Ridgeline Technology. She incorporated it in Illinois. She listed herself as founder and sole director. She did not put anyone else's name on anything. The 3 NDAs were a different story. It took 8 more months. 4 attorneys, 2 jurisdictions, 1 case that settled quietly, and one that went far enough to generate a letter from Randall's team, asking Vivienne to please not encourage further litigation against him. She had written back through Dorothy that she had no control over the decisions of independent parties. The third woman, the one with the employment discrimination claim, settled in February of the following year. The terms were confidential. What was not confidential was that she used part of her settlement to go back to school, and that she sent Vivienne a card afterward that said thank you and nothing else. And that Vivienne kept it in the top drawer of her desk at Ridgeline, under the original handwritten notes from the architecture she'd designed in the second bedroom, the ones she'd never thrown away, because she'd always believed that where things begin matters. She was in the Ridgeline office on a Thursday afternoon in March, when her phone rang, and it was a journalist from a technology publication she respected, asking if she would comment on reports that Ashford and Vale had lost 2 major commercial real estate clients in the past quarter and was under review by a third, following questions about the underlying reliability of the systems those properties depended on. Vivienne thought about that. She thought about the architecture she had written and the license that Randall now needed her permission to maintain, and the fact that the license renewal had been due in January and her LLC had sent notice of updated terms, which his team had rejected, and the subsequent exchange of correspondence that had been, diplomatically speaking, unresolved. "I can't speak to Ashford and Vale's client relationships," she said. "But I can tell you that Ridgeline Technology is the licensor of record for those systems. Any questions about their technical reliability would be best directed to us." The journalist asked if she would be available for a longer interview. "Yes," she said, "I'd like that." She set down the phone. Through the window of her corner office, her office in her building, with her company's name on the door, the city was doing what Chicago does in March, which is to be cold and bright and indifferent, and also, somehow, full of the specific feeling that spring is not impossible. She had always loved that about this city, the stubbornness of it, the way it kept going. She picked up her coffee and got back to work.